The Wesley Methodist Church was packed to capacity this morning, but its occupants were not the regular man on the street. In fact, they were the people who make up the bench and bar, and included the Governor General, Sir Colville Young, U.S. Ambassador to Belize, Vinay Tumalapalli, and other dignitaries. It was the opening of the 2012 Supreme Court calendar. And following the traditional pomp and ceremony in front of the Courthouse Plaza, the Chief Justice, Kenneth Benjamin, delivered his annual report. As has been the case in previous years, the budget allocated for judicial affairs continues to be a pressing concern, with the judiciary receiving just over 1% of the entire national budget.
The approved allocation by central government to the judiciary during the fiscal year 2011 to 2012 stands at $7,891,108 against a national budget of $729,553,334. The judiciary shares in 1.08% of the said national budget.
But the judiciary's budget was but one of the many concerns. While there are 9 sitting judges, criminal cases have exacerbated the already swamped court calendar, and murder cases have increased at an alarming rate.
For a reason which will become apparent later on, the Chief Justice will be undertaking the hearing of certain criminal matters in the course of 2012 and perhaps beyond. The establishment makes provision for an additional judge to be appointed. This appointment will not be made in the coming year and will be informed by the data that will emerge from a comprehensive statistical assessment of the caseload and case disposal rate in both the criminal and civil divisions. The court lists for all the judicial districts have grown to the point where the ability of the courts to dispose of cases has been effectively outstripped. This state of affairs has compromised the capacity of the criminal justice system to dispose of all cases in an expeditious time frame. In an effort to explore at least one option, it is my intention to resuscitate a committee commissioned by my predecessor in office to devise rules for the introduction of case management techniques, complete with timelines for the disposal of cases in both the inferior courts and the Supreme Court.
The Chief Justice also issued a call to all practitioners of criminal law to render their assistance to take on murder cases and to speed up the process where necessary. The court will also begin to encourage more settlement discussions, primarily in civil matters, rather than to have full drawn-out matters that take up much of the court's time.
The time has come for the Supreme Court to adopt a multi-door approach to the resolution of disputes by offering to litigants mediation services under its auspices. For such an undertaking to be successful, the court must be vigilant in offering a process that is imbued with efficiency and integrity. Her Ladyship, Madam Justice Hafiz Bertrand, has kindly consented to give of her valuable time to shepherd the creation and implementation of a system of mediation.
The system of trial without a jury to take effect this year should also expedite the process. But those cases, which always originate at the magistrate's level, take up much of the lower court's time before they are finally transferred to the Supreme Court. Currently, 6 magistrates are on training abroad, and their return, coupled with the construction of an entirely new magistrates' court in Independence Village, should also help to speed up the trials process for the southern districts. And while the bench and bar were at odds in the past, the CJ called on the president of the Bar Association, Jacqueline Marshallek, to enter into meaningful discussion, to put aside misunderstandings, and to start anew. Marshallek focused on the need for quality of service as opposed to quantity, and said that everyone has their part to do, from investigator to prosecutor to judge.
There is a need to carefully examine whether or not this increase is primarily due to a lack of confidence in the quality of decisions being delivered at the Supreme Court level, or whether the number of claims filed in the Supreme Court has significantly increased, so there are simply more appeals being taken in the normal course. Perhaps it is a combination of these and other factors. Whatever the reason or reasons, the number of matters being set down for appeal has swelled, and there is pressure on our Court of Appeal to address the large numbers of appeals in a timely fashion. This matter needs to be addressed sooner rather than later if we wish to avoid a serious backlog in our appeals process. On the criminal side, 2012 will require that we continue to address the problems identified in 2011. In relation to criminal matters, all of the stakeholders have to bring their A game. The police will have to conduct thorough investigations which are not wholly reliant on eyewitness testimony. Prosecutors have to prepare solid cases that will stand against seasoned defense counsel. 2012 will also usher in the era of trial by judge alone in certain indictable matters, and so our judges will come under pressure to prepare a new form of judgment that will stand the test on appeal.
And while the judges' rulings will be tested on appeal, Attorney General B.Q. Pitts challenged the members of the bar to respect each other and members of the bench, and used an undertaking by a senior counsel on the passing of another senior counsel to urge everyone to show respect.
The death of one of our most illustrious members of our profession, Dr. Elston Kasiki, that another illustrious colleague and senior counsel, Mr. Michael Young, saw it fit to circulate in an email to all of us to respect each other and to act as lawyers should, and remember that we are all officers of the court or an integral part of the administration of justice.
The 2012 criminal calendar will begin on Tuesday with pleas. Reporting for Love News, I am Marian Ali.